Let's get back to this conversation then today. Civil society launching a campaign, various pillars against the amended electoral bill. They're saying this could be quite dangerous to democracy and to the electoral process itself because it is flawed on a number of levels, including one, of course, around the principle of representation. Tselane, chairperson of the Institute of Election Management Services in Africa, still with us. So you're saying that the parliamentarians failed to deal with what the Constitutional Court said they must comply with as far as the conditions that are set out in what should be in our electoral bill?
Absolutely. What the Constitutional Court has essentially said to Parliament was that Parliament must create a system where adult citizens can be able to participate in the electoral process as candidates without necessarily having to be part of the membership of a political party. So what this means is that Parliament has got to establish a system where an individual who wants to contest the elections may do so. But it is a broader right that is actually protected in terms of Section 18 and Section 19 of the Constitution, which basically gives the adult citizens the right to be able to stand for office and to be elected into office, once the process has gone through the electoral processes. Now, one of the defects of the current bill is that when an adult citizen who has actually made himself or herself available as an independent vacates an office for one reason or another or dies, that particular seat is forfeited to a political party. This is what I refer to as a withering of the seat of independence. And then the Constitution could not have anticipated a situation where seats would only be temporarily available for individuals who want to contest as independents, and immediately after a person who has actually occupied the position vacates office, then that seat is forfeited to a political party. It defeats the whole purpose of why, in the first instance, the Constitutional Court came up with this judgment.
Yeah. One of the issues being raised around this particular system is that it is a unique system that does not exist anywhere in the world. Now, you have, of course, been at the Independent Electoral Commission. You have also, in your own capacity now as an independent consultant, looked at elections in various parts of the world. Is this in any way resembling a multi-member constituency system?
No, it doesn't. That's why we are saying that the bill as it currently stands is defective, and then we are trying to urge parliamentarians and Parliament to take a look at the provisions that are there within the bill, because firstly, it does not meet the requirements of the Constitution, but also you cannot actually even be able to compare it with any system that exists anywhere in the world. So to the extent that it's almost like a cut and paste of various aspects of systems throughout the world. It does not really have the coherence that a system that's supposed to be there, exists, and that's supposed to be understood by both the people who are going to be running the elections as well as the electorate.
So if the system was to uphold the principle of representation, what is it supposed to allow? Because currently I believe each constituency can, for example, nominate whatever number of candidates to go to Parliament, but you can only vote for one. So it is, in its essence, if it was upholding the principle of representation, what would that kind of arrangement look like?
Firstly, the country was supposed to have been cut into constituencies, and not to try to cut the current arrangement where you've got 9 provinces and now turning them into regions and saying that those are the constituencies. There is a structure that has been established in the past that is actually dealing with the demarcation of boundaries. That structure is the Demarcation Board. In my opinion, a Demarcation Board, because it's got the data sets of the whole country, should have actually been given the powers to be able to assist Parliament by coming up with clearly defined areas that can be regarded as constituencies. But it's got to be based on a scientific mechanism that can actually be justifiable. At the moment, what Parliament or whoever the drafters are of this bill appear to have just taken the current arrangement of Parliament and the provinces and then try to cut those provinces into various regions and saying these regions will represent constituencies. So it is one of that obviously would then lead to the kind of the problem that it has. But also even people who are supposed to be contesting the elections as independents, there is inequality between them and the political parties in terms of how many votes a person is required to gather in order to be able to get a seat. And then what happens to the number of votes if they exceed the number of votes that a candidate would require in order to be able to qualify for a seat.
Yeah. Highlight that unfairness for us. Just expose it a little bit. So I believe political parties, for example, are required to have 1,000 signatories, while independent candidates would need to have 10,000.
No, for political parties, actually, to be able to register as a political party, you require 500 votes. And then there are certain requirements as well that you've got to follow that would then entitle you to register as a political party. And then once you have registered as a political party, there would be certain requirements that the IEC would introduce closer to the elections that would enable a political party to participate in the process. But the number of signatures that are required for a candidate to stand as a candidate in elections, as an independent candidate, far exceeds the number of signatures that are required for a political party to basically register as a political party.
Now, the other issue being highlighted in Tselane is the accountability deficit, that what we sought to do was to move away from proportional representation, which was good at the time when we went into elections in 1994, to make sure that everybody, every voice gets to be represented. But the system now needs to speak to the current challenges of the time, which is, of course, we need a little bit more of accountability from those we put into public office. What is the deficit currently in the bill around accountability?
Well, the problem that is there is actually the power to recall a person who has actually been elected into office if you are not satisfied with the performance of that particular individual. But the issue really is not really to do away with proportional representation system. Proportional representation system does exist in the Constitution and is protected by the Constitution. But proportional representation system does not negate individual citizens standing as an individual or as an independent to contest the election. So there is no attempt to do away with the proportional representation system. As I've indicated, the Constitution does protect the proportional representation system, but it allows, in addition to that, for individual citizens, for other citizens, to be able to contest without necessarily having to have a membership of a political party.
In your view, can we still organize the elections in 2024 with, I suppose, the current bill?
I'm very anxious about the possibility of having the elections in 2024. I think that given all these challenges that we have and the weaknesses in that bill, I do not think that it is going to be possible to have the elections within a constitutionally stipulated period. Firstly, if this bill does not meet the constitutional muster, it means it's going to be challenged. And then the IEC, as it is, does not have sufficient time to prepare for the elections. But it's not only the IEC. You may recall that Justice Matlanga, when he issued this judgment, had indicated the reason why he wanted Parliament to have only 24 months to deal with this. There were two reasons. One was that they wanted to allow IEC to have sufficient time to have a smooth election. But secondly, for those who are intending to contest the elections, also to be able to campaign in their constituencies and then be able to prepare for the elections properly. But given the fact that Parliament actually went into the Constitutional Court to ask for extension, that is already beginning to encroach in the time that the IEC would require to prepare for the elections. But it is not only that, as I've indicated, the bill itself, I don't think it would actually be able to pass the constitutional muster. So I think the appeal really to Parliament and to parliamentarians is please try to take note of some of the issues and criticism that have been raised because this may unnecessarily delay the delivery of the elections in 2024.
If the parliamentarians, if the president insists on going ahead and signing this particular amended bill, is there legal recourse that society, communities, and maybe organized civil society can pursue?
Well, courts are always there available for people who are not happy with the system to take the issues through the courts. It is not something that is not disallowed in the Constitution. That's why we've got the electoral court. But also, if something does not meet the constitutional muster, can still be referred to the Constitutional Court to deal with. So it's an option available to citizens, either through their organized formations or as individuals. They can still approach either the Constitutional Court or the Electoral Court. But as I've indicated, unfortunately, this risks also delaying the delivery of the elections in 2024.
Tselane, I appreciate your time. Thank you so much for joining us tonight here on In Focus. That is the chairperson of the Institute of Election Management Services in Africa.